I'm really happy to have Ashish Joshi here. He's a lawyer in Michigan who deals a lot with parental alienation. And I think that's one of the aspects. A lot of these cases head to court, unfortunately. And I'm really pleased that he's able to spend some time with us to help us kind of work through some of the intricacies and interesting things that can happen when you take this to court. So thank you very much for joining me.
Thank you, David. It's a pleasure.
So one of the things I want to ask you right off the bat, how is parental alienation actually treated in the courts? Is it really considered seriously now?
It is. From where we used to be about 10 years ago, 15 years ago, if you look at the progress in the courts, more and more courts are acknowledging that parental alienation exists. It's a serious thing and something needs to be done about it. So we used to see a lot more skepticism from the courts early on. And there was a confusion as to whether it's a syndrome or not, whether it's in DSM-5, whether it's a valid theory, having scientific support and all that. And we have come a long way since then. As of today, overwhelming amount of family courts around the country have acknowledged parental alienation and have provided intervention when they have found evidence of moderate to severe alienation in cases.
So I know that the opposing side will often say it's all, you kind of alluded to it, it's all junk science, it's not real, it's not in the DSM-5. Can you step us through, like, what is the process that you use in court to kind of overcome these accusations that it's not real? And how do you get the courts and the judges to understand that alienation has happened and that it's not just simply estrangement, you know, where someone's abused their children and there's a legitimate reason for the child not to want a relationship?
Sure. So let's pass to the arguments. The argument that parental alienation is junk science and doesn't exist, that I don't see that happening anymore. There'll be a rare case where an attorney would step into a courtroom and say, Your Honor, this entire theory of alienation is junk science. It simply doesn't exist. Because you don't want to look like a fool. You know, you don't want to come across and be like, the judge is going to stare at you and wonder what's wrong with you. Because we have cases, we have published cases, we have unpublished judicial opinions from almost every jurisdiction that have acknowledged parental alienation. So it used to happen that way. They would say it's junk science, but now we don't see that, thankfully, anymore. What you do see is an argument that it doesn't exist in this particular case, that this case, the child is rejecting the parent or resisting contact with the parent because the parent is abusive, has significantly deficient parenting style. There's been historically domestic violence, abandonment, neglectful behavior, whatnot. And that's a factual issue. So the judges typically, what they do is they order either a custody evaluation, or sometimes in some jurisdictions, they order the friend of the court to conduct an investigation. Sometimes they appoint guardians ad litem to do an investigation in the case. And thereafter, if you are the proponent of parental alienation theory, it's on you, the attorney representing the targeted parent, to go back into the court and prove your case. You can do it in several ways. I typically like to use the 5-factor model, which is to show the 5 factors existing in the case in tandem, in conjunction with each other. So the factor 1 is that there is evidence of the child rejecting the parent or resisting contact with the parent. And it's important to note that it's not necessary that children should absolutely refuse to go to parenting time in order for a case to be a case of alienation. You can have cases where kids do go on parenting time, but there is an absolute refusal to engage with the parent. You see cases where the kids walk into the parents' home with the headphones on, just go into the bedroom, lock the door. They come prepared with the bags full of snacks and food items. They don't just come out, no dinners, no lunches, no conversation, no outings. It's like they're just there to check the box for the parenting time. And that very well could be a case of alienation. So you look at the relationship because it's an equation that is quantitative and qualitative. You look at the quantity of parenting time that's being lost, the actual rejection of the parent, but you also look at the loss of the inherent relationship. Was the relationship really good or normative not too long ago? And what is it now? That's the first factor. The second factor is there has to be historically somewhat of a decent, normal relationship between the now rejected parent and the child. So, in other words, the parent who is now being rejected and the child is resisting contact with the parent, that parent was an involved parent in the child's life not too long ago, before the separation or divorce. So, you look at the evidence of the parent being active with the school activities, sporting activities, vacation pictures, birthday pictures, like any other parent, that parent was involved in the child's life. And you see the baseline evidence of a good relationship. The third factor is that, and this is somewhat more controversial, and it's mostly litigated in courtrooms. The third factor is absence of abuse or neglect or significantly deficient parenting. And this is where the other side might come up and say, well, the father or mother is abusive, and that's why the kid doesn't want to see the parent. And you have to parse this very carefully. What the science tells us and what you look for is absence of abusive behavior. And that's abuse is a higher standard. We are not talking about one parent being a rule follower and being strict on control of media, for example, or being strict on homework, or having somewhat of an authoritative parenting style. We are talking about abusive behavior, where the protective services have investigated the matter, found someone to be physically abusive, mentally abusive, significantly deficient parenting that would give anyone a pause, or the parent being an absentee parent, not involved in the child's life from the very get-go. So you look at those things and you try to figure out whether these deficiencies that are being complained about, do they rise to the level where a child would reject a parent? Because the research shows us, and this is very interesting, David, and counterintuitive. The research shows us that truly abused children, children who have been genuinely abused, have been taken away from the parents by the protective services and the courts and have been placed in foster care system. They are desperate to go back to the abusive parents. These children will make excuses for the abusive behaviors. They will fight to keep that link with the abusive parent, that relationship alive. Whereas in an alienation situation, any insignificant flaw, any excuse is portrayed as, well, this is not good enough. I don't want to see the mom for the rest of my life. So you see that the rejection is disproportionate to the action complained about. And that's a hallmark of an alienation case. Factor 4 is evidence of alienating behaviors. There are well-known alienating strategies. Dr. Amy Baker and her colleagues have done significant work on that. And it's remarkable that these alienating behaviors, they are constant somewhat across the board, across the cultures. So you study a group in Italy, or you study a group in America, or you study somewhere in India, and these behaviors are very uniform, and they are very much similar across the cultures, across the continents. And there needs to be evidence of these alienating behaviors. You simply can't assume that because a child is rejecting a parent, the parent must have done something wrong. Last factor is factor 5, where you show that there are signs of alienation in the child or children. And there are well-known 8 symptoms of alienation. And the child doesn't need to demonstrate all 8, much as the alienating parent doesn't need to demonstrate all 17 behaviors. You could have 4 or 5 or 6 and still have a case of moderate to severe alienation. So you put all these factors together, and then you try to prove your case in a court of law. Sometimes clinical findings are made as part of the custody evaluation or psychological evaluation. Sometimes the court just take it to a trial. But more and more judges are finding facts on their own. In fact, there was a great decision from your neck of the woods recently, from Ontario Court of Appeals, that the fact that parental alienation exists is well known. And judges can take a judicial notice of that phenomenon. We don't need a debate. We don't need an argument as to whether it exists or not. It does exist. We are not going to waste time on deciding whether it exists or not. This creature has been found in the forest. We have seen it alive and kicking. It does exist. So let's move on to whether it exists in this particular case or not. And that's what we are seeing more and more now.
Okay, that's excellent. So I just want to really quickly go back and revisit the third one, where abuse. Some parents use corporal punishment. Some parents may, occasionally yell and scream, or maybe even just the situation in the home might be such that it's always tense. Now, in a situation like that, if a parent wants to, all parents, no parent's perfect. I don't think any parent's perfect. They all slip up. How does a parent, who, let's suppose a parent is alcoholic, and they're reforming and they're trying to change, how would they deal with that? Is the case lost for them if they've had some transgressions? What can they do? Do they need witnesses? What would be some steps that a parent who isn't perfect, what should they do for that third factor?
That's a great question. So let's take a step back. If there are genuine issues where a child is rejecting a parent for legitimate reasons, let's suppose we have a parent who is an alcoholic, and there are instances where the parent has been in car accidents, or he or she has behaved in a remarkably inappropriate way because under influence of alcohol or whatnot, and the child has been witness to those behaviors and is embarrassed, humiliated, afraid, then those are legitimate reasons where a child could resist the parent or have no contact with the parent. So it's important to not rush into the court and scream parental alienation, because you will lose credibility with the court. You will send a signal that you consider your behavior to be absolutely of no consequence, and it's all the fault of the other parent why the child is resisting contact. And credibility is the key in any litigation. Once you lose a credibility with the court, it's very difficult to get it back. So before making an allegation of parental alienation, which I consider to be child emotional abuse, and many courts do as well, you have to take a good, hard look at the facts. And that's where I sometimes sit down with the clients and talk to them that your case is not a classic case of parental alienation, at least not yet. You do have evidence of some undermining, alienating behaviors. But on the other hand, you also have some significant issues to deal with at your end. So let's deal with those and then talk about where we are. So if a parent wants to make amends, let's say the parent goes to a rehab facility. They agree to go for random drug testing or alcohol testing. They are trying to get their life back on the track, and they have evidence to show that. And despite that, the child's complaint against the parent remains constant. You were an alcoholic, you are an alcoholic, you drink, I refuse to believe anything else, and I don't care what the test results show. And the other parent continues to foster that belief, continues to overempower the child, continues to engage in alienating behaviors, then yes, we do have a problem. There are cases where the courts have found at the first roundabout, let's say a trial, that it's not an alienation case, it's a hybrid case. That the rejected parent has demonstrated some questionable behaviors or has some issues such as alcoholism in this example that needs to be worked on. And the other parent is over empowering the child and undermining the other parent and has engaged in some alienating behaviors. But nonetheless, because of the dynamic, it's a hybrid case. Fast forward 9 months, 10 months, maybe a year or two, the court could make a different finding. And courts have done that. The courts have realized that 2 years ago, we found this case to be of a hybrid nature. 2 years down the line, the rejected parent, let's suppose it's the mother. The rejected parent, the mother has gone through a rehab facility. The mother has gone through continuous, regular, random alcohol testing. There have been no issues of alcohol consumption. However, the child refuses to move forward. The child is still caught in the past. And the other parent continues to engage in the same alienating behaviors that he did earlier. And at this point in time, it's no longer a case of hybrid nature. It is a case of parental alienation. And the courts have done that. There was a case out of Michigan 2 years ago, a published case, where the court just did that.
Okay, that's very interesting. Now, you also mentioned about counseling, getting help. And when I look at some of the websites and look at how people are behaving, there's a lot of hurt, desperation, anger. How important is it for a client to get counseling so they don't bring that baggage into the courtroom? Because it sounds like if they do bring that baggage into the courtroom, it could actually hurt them as opposed to getting sympathy. Because, there's a lot of pain and grief and anger and frustration.
Absolutely. I think counseling can be extremely helpful. It can be very valuable. Sometimes parenting coaching as well. Going through a case of alienation is very painful. On the one hand, you are dealing with the frustration because the family courts, the system moves slow. Often there are months go by before you get a court hearing. Particularly with the COVID situation, the courts are backlogged as well. And during this time, your life continues. On an almost daily basis, you are being rejected by your flesh and blood. Your text messages go unreturned. Your phone calls go unreturned, unanswered. You are not able to see the child. The child continues to resist, be defiant, be extremely disrespectful towards you. So in some situations, in significantly severe cases, the rejected parent is undergoing trauma. And they need tools to cope up with that. They need tools to deal with that, to not lash out, to not respond in an angry manner, because those text messages or those issues or those lashing out will then be used against the parent in court to show, well, see how angry he gets? Do you see how angry the text message was? He has no empathy. This is why the kid's rejecting the father. So there's a confusion between reaction of a targeted parent to alienation, and that's being confused with the causation. What caused the dysfunction in the first place? If you go to Facebook, for example, or any social media platform, you will find this rejected parents, targeted parents, parents who are wrestling with the situation, just lash out. They talk about how bad the judges are, how the lawyers are idiots, didn't get it, how the system is corrupt, no one else gets it. They sometimes post pictures of the children. They post pictures of their ex. They divulge details about the courtroom, the case details, They ask for advice on Facebook, and everyone has an opinion, obviously. And these don't help. They could extremely hurt your, these could actually hurt your case. It could tank your credibility in a court of law. And I have seen that repeatedly happen, that the opposing counsel sometimes picks out some choicest postings on Facebook and cross-examines a parent on the stand. And there you have some poor decisions talking about kids, and sometimes the children find them. If you have children who are older, they might find those postings, they might question them, they might be embarrassed by it. They don't want to be pointed out in photographs and whatnot. So a good counselor would help with all these issues. And I always tell the clients that I'm your attorney, I'm not your therapist. So it doesn't help when you unload on your lawyer and you treat your lawyer as your therapist or just need to vent. You need a good counselor who can help you navigate this system, navigate litigation, and deal with the rejection on one hand, but still be able to compartmentalize that and focus on the case where the focus needs to be. At the end of the day, the courts expect the parents to be adults. Children could be rude, defiant, disrespectful, and the courts will deal with that. But if the behavior from the parent is equally disrespectful, lashing out, angry, courts typically don't like it. And you might cause an otherwise good case of alienation. You might lead the court to believe it's a hybrid case. And that just would be a tragedy.
Yeah.
Because then the court will not give you the intervention that you desperately need in an alienation case. It will send you off to some family therapy or joint therapy to help you work on your quote unquote anger issues. And it spirals downward from there.
So it sounds like it could be a lot, you mentioned a very long process, and it can be very expensive. And I know a lot of parents may not have the means to pursue this. What should a parent do in that particular case? You know, the person that doesn't have, is there anything they can do if they don't have the financial means to battle this?
Well, David, I believe up to, I think the percentage of pro se litigants in United States in family courts is somewhere about 65 to 70%. That 65 to 70% of people in family courts represent themselves. Now, it could vary, of course, depending on jurisdiction, but that's a baseline statistic that I read some time ago. So like in any other situation, you know, if you are going through a criminal defense case, you're going through a landlord-tenant case, whatever the case or controversy might be, you read up on the law, you learn how to file a complaint, you learn how to file a motion, you have to do the case law research in the jurisdiction. Much of the resources are available online, free sometimes. In some jurisdictions, you have the availability of legal aid, and you have lawyers who can help you out with on some issues. Unfortunately, you don't see that often in family law arenas, but you just have to sit back and learn how to deal with the system. It's a completely different situation. A lot of it is procedure. A lot of it is you have to jump through the hoops to get a hearing before the court. You learn the difference between a motion argument and an evidentiary hearing, where in some cases you are just making an argument to the court for some relief. In other cases, you're actually presenting evidence. You're putting your witness on the stand, getting testimony out, having cross-examination going on with other witnesses and all that. There are some good resources. I recently wrote a book about this very topic. It's called Litigating Parental Alienation. It's published by the American Bar Association. And in that book, I explain how to present a case of parental alienation in a court of law. It doesn't matter whether you are in California or New York or New Jersey. The procedural aspects may differ. Some courts require a particular format, some courts require a particular timeline, and whatnot. But at the end of the day, what controls the decision making of courts is the best interest factors. And these best interest factors for the children are very much similar across the board. There's also another good book called Parental Alienation, Science and Law, which was published in 2020. Half of the book focuses on the peer-reviewed empirical science supporting the theory of parental alienation. And the other half talks about the legal issues involved, a survey of decisions across the country on alienation. But let's say you are in the state of New York and you need to represent yourself because you run out of money, you don't have resources, or you think you could do a better job than your lawyer could. In that situation, you have to first understand how a particular motion is filed with the court of law. Sometimes clerks of the courts are helpful, sometimes not. They are not allowed to give legal advice to you, obviously. But you then look at the cases. You go and research how New York courts have looked at parental alienation in the, let's say, past 5 to 10 years. Take out some good decisions, put the facts of your case before the judge. And judges do give some leeway to people who represent themselves. I have seen that happen. So let's say in some technical issues, if you file a motion that is 2 pages or 5 pages over the length permitted, if you are an attorney, the judge will hold your feet to the fire and we expect you to know the court rules. If you are a pro se litigant that is representing yourself, you might get some leeway from the court. The judge might look at you and say, well, Mr. So-and-so, you have filed a 25-page motion. The page limit is 10 pages. Please keep that in mind the next time you file something in the court. And it goes from there. It's not impossible. I have seen it happen. I have seen parents represent themselves and do a decent job. And like any other skill, the more you do it, the more you read, the more you learn about it.
So if a parent does have the financial means and they want to reach out, is it better to find a lawyer in your local area, or can they reach out to, obviously there's networks of lawyers who are familiar with parental alienation. Is it worth it for them to kind of look internationally even to find a lawyer, or is it better, because jurisdictions matter a little bit at least, to find someone locally? And how do they do that?
Well, you need, if you are, sure, if you want a lawyer, you have to have someone who is licensed in that jurisdiction. But so let me give you an example. So I litigate cases involving parental alienation across the country. I'm admitted in New York, Michigan, District of Columbia as an attorney. Let's say I have a case in Wyoming. If I represent a client in a court in Wyoming, I'm required to associate myself with a local counsel for that case. So typically, the client would already have a Wyoming lawyer, and they are wrestling with a complicated, complex issue. Let's say they have a therapist who believes that this is not alienation, who is over-empowering the child, who is coming to the court to testify, and the client wants a specialist attorney who has knowledge of alienation to cross-examine that particular witness. So I would get a call, but at all given times, the Wyoming attorney has to be associated in the case, will continue to be the lead attorney, and I do a part of the case. I help out in some situations. Sometimes I take over the case and become a lead attorney. But you need the local attorney to be there. You can't just have an out-of-state attorney as your sole lead attorney without having a local counsel on board. So that's the first rule. In terms of selecting an attorney, I think it's important to do your due diligence. I think it's, you wouldn't go to, if you have a particular medical problem, you go to your PCP and ask for recommendations. I want to go and see a cardiac specialist, or I want to go and see a neurosurgeon, because that's a specialized area of practice. In much ways, issues involving parental alienation, pathological enmeshment, child abuse, there's little specialized area of law. And an attorney specializing in those areas will have more understanding, skill, and experience in dealing with them than an attorney who simply does divorce cases or child custody cases day in and day out and might have an alienation case once in a year or twice in a year. So you ask questions. Have you handled a case of parental alienation? Was it a mild, moderate, or severe alienation case? Were you successful in proving alienation in a court of law? How did you go about doing that? Did the court agree with you? What sort of intervention were you able to get? These are the facts present in my case. Do you think it's an alienation case? Why? And I think initial questions, getting a good consultation up front would be really helpful. What you don't want is to go to an attorney, retain the attorney, pay the money, spend time in educating the attorney, and 6 months down the road, the lawyer tells you, you know what, even though I agree with you, it's an alienation case, I wouldn't make that noise. I wouldn't say those words. So-and-so judge doesn't like it, or our system or our courts don't necessarily agree with that. So just let's go to mediation, let's go to therapy, and just be patient, and hopefully it'll work. Because if it's truly a case of alienation, it doesn't work. Moderation kills. Taking baby steps could lead to loss of your children and the relationship. You need to act fast. You need immediate intervention. And you need to know upfront whether your lawyer is willing to go to the mat for you. Now, I'm not saying that if the lawyer disagrees at the outset that it's not a case of parental alienation, then you shouldn't be propounding a theory in search of facts. You know, the facts have to support the theory. But if you do have facts to support your theory, then it's absolutely critical that you get the intervention that you need as fast as possible.
Excellent advice. I guess with all the recent, Erasing Families documentary, there seems to be groups now trying to introduce legislation about parental alienation. Do you see optimism? Are things changing, say, from 5 years ago or 10 years ago? Does there seem to be more information out there, and is society finally starting to recognize parental alienation?
I would say my answer would be a qualified yes. And I'll tell you why. I do have a sense of optimism in that the courts are coming out with remarkably good decisions. In fact, you are from Canada, and I consider Canadian courts to be in the vanguard of the fight against alienation. Canadian decisions are some of the best decisions in the entire world. When you compare family courts and decisions on alienation, you have Canada, UK, US, Australia, New Zealand, other jurisdictions. Canadian courts, in my opinion, have come up with the best decisions, best reasoned opinions as well. So you do see a sense of optimism that courts are acknowledging alienation. They are intervening in severe cases. They are providing change of custody. They are providing required specialized intervention and all of that. At the same time, because the term alienation, parental alienation, is now in the mainstream and has got a lot of attention in the past several years, it's also being used in cases where it doesn't belong. It's sort of an overkill zone. I mean, I get calls from around the country all the time. My case is a severe case of alienation. You would have seen clients rushing with the alienation determination, having made without talking to a lawyer, having gone through an evaluation. And that doesn't help you. You know, you could still get some decent intervention from the court. You could still get the relief or the remedy that you need in your case without calling your case a case of parental alienation. For example, if you have evidence that your ex is undermining you as a parent, is repeatedly interfering with your parenting time, is repeatedly sabotaging your relationship with the child, throwing out all sorts of obstacles and all that, refusing to follow the court orders, you could still have a good case, but it may not be a case of alienation. The child may not be alienated. The child may not show symptoms of alienation. That doesn't mean you sit back and let those things happen. You can go to court. You can point those things out. But you don't need to put a label on it. You don't need to call it parental alienation. So that's important to understand. And often cases get derailed on fights that don't go anywhere. Because the other side will say, Your Honor, it's not alienation. We would like to conduct discovery. We like to conduct deposition. Let's have an evidentiary hearing. They bring an expert. You bring an expert, and you're fighting over whether it exists or not. Whereas you could simply point out those negative, bad behaviors to a trial judge, and any trial judge in family law would recognize that those behaviors are not in the best interest of the child. So you have to cut through the lot of smoke screen here and focus on what matters.
Oh, lots to unpack. Thank you so much. I'm going to put a link to your book. It sounds like an excellent resource, and I'll also put a link to your office. And I really want to thank you for this time. And I hope if we have future questions that I can call on you again and get your expert opinion.
Thank you, David. It was a pleasure being with you.
Thanks so much.